Hi, I'm David Marchant, the founder of OffshoreAlert, which investigates participants in high-value cross-border finance with an emphasis on high-confidentiality jurisdictions. Our specialty is exposing investment fraud while it's in progress. Enjoy our content.
Well, good morning or good afternoon, depending on where you are. We are very pleased to present to you a presentation this morning on understanding how litigation claims get funded. We have a very distinguished panel, except for myself. Ralph Sutton is my name, but we have Chris DeLise and Dave Kerstein, who I'll tell you about in a second. And we are going to share with you some insights that we have from our perspectives in different funding groups, and also give you an overview of current trends in litigation that we see, and the construction of a term sheet and the elements of how a claim gets funded from the inside of a couple of funding groups. So first, let me tell you about our panelists. Chris DeLise is the Managing Partner, Chief Executive Officer, and Co-Chief Investment Officer for Delta Capital Partners Management, a US-based global private equity firm specializing in litigation and legal finance, judgment enforcement, asset recovery, and related strategies. Chris previously was an equity partner at K&L Gates, chairman of the private investment funds practice group at Hush Blackwell, and was a private equity attorney at DLA Piper. Dave Kerstein is the chief risk officer and senior investment manager at Validity Finance. Dave also was an investment manager for about 5 years at Bentham IMF. He was, prior to his funding career, a practicing lawyer at Gibson, Dunn and Crutcher for 15 years. So I'm Ralph Sutton, founder and CEO of Validity Finance. I'm a former chief investment officer at Bentham IMF for 6 years, where I oversaw a large number of investments as the US arm of that publicly traded Australian company. I began funding at Credit Suisse in 2006, and prior to that practiced commercial litigation for most of 20 years. So let me start with you, Chris, if I could. Tell us what you're seeing in the market in this very interesting and provocative period of time during the COVID crisis.
Sure. Thanks, Ralph. Good to be here this morning with both of you. It has been an interesting year, as we all know, in the funding space. What we've seen is several trends. I think one that was somewhat unanticipated by us, at least at Delta, is an increased demand for credit-oriented products. So, as most people know, 99% of litigation finance are equity-oriented products. The funder is buying a share of the projected future economics from a case, arbitration and enforcement action, et cetera. And what we've started to see, I think in part because of the increased demand for liquidity by not only law firms, but claimants who hold claims, judgments, or awards, is an increased demand for a credit structure. So this could be something like a loan against a claim, a loan against a judgment or award already obtained, or a capital facility that is for a law firm that is utilizing its cases as collateral against which they borrow. And that could be a term loan, it could be a revolving facility, et cetera. So it's an interesting trend in the marketplace because it results in lower overall cost of capital for the claimant or the end user. And for the funder, it's a way to, if you will, smooth out cash flows from having episodic equity-only products. We've also seen that prospective investors have been interested in this type of product. So this is something we're further exploring I'll note one final comment is credit-oriented products have kind of always existed in more personal injury, med-mal, plaintiff-oriented cases where people regularly borrow against judgments or awards that they obtain on a personal level or a class action level. This is taking it to the next level where you're dealing with corporate enterprises and commercial cases. Dave, I don't know if you want to comment on that particular aspect of the trends.
Yeah, no, I think that's a good summary, Chris. I mean, I think as you can see on our slide, a couple of the other trends that we've seen recently over the last few years is really an uptick in interest and use of litigation finance amongst larger firms and the AmLaw 100 firms specifically, firms that didn't used to want to even necessarily talk to funders are now, if not using, at least considering using funding, and some of them on a more systematic basis. We've seen a number of large firms set up task forces or committees to institutionalize, in a sense, the use of litigation finance at their law firms, rather than just sort of having one-off partners or other lawyers at the firm using funding and trying to systematize their use of it and education of the firm for funding. In addition, we've seen some firms that are even set up based upon using funding as part of their business model. And then we've been approached by a number of law firms to set up sort of bespoke large portfolios for use in the firm for risk sharing and for other to help them solve problems that they're experiencing in this economic environment. When COVID sort of first struck earlier this year, we saw a really large uptick, as I think Chris likely did and other funders did, in the number of leads and outreaches that were made to explore the use of funding amongst all sorts of firms. Many of those were possibly panicky people who were exploring any potential way to get capital. But while it leveled out somewhat, we've still seen about 1.5 times the amount of leads coming in. So what we've experienced is basically there was already a trend towards increased use of litigation finance amongst law firms in general and the AmLaw in particular. But the COVID and the macroeconomic environment has seemed to sort of accelerate and those trends.
Chris,
I would agree.
You've got a point, there about direct solicitation, but I want to hear if you have a different point of view about Dave's point.
Sure. So, no, I agree with Dave. We started to see about 18 months ago, large law firms, typically AmLaw 100, Global 200, looking at institutionalizing the process from which they obtain litigation finance. So initially, as most of us know, every partner in the firm who had a client that wanted funding would be calling you. So from a funding standpoint, it was a disorganized process, right? You could be talking to someone in London who wanted one thing, but they needed to get sign-off from the management committee. Then by the time it went to the management committee, the deal was completely different. Then you've got the CFO and managing partners trying to manage receivables and WIP, and they would come to you for something that was more bespoke. So it's a welcome trend, I think, in our industry to see that more firms, and now even mid-sized firms, are moving away from everyone does their own thing to let's assign it to a committee, a group, a task force, a couple of partners, so that they can better familiarize themselves with what it is that we offer. And if you will, educate internally all of the attorneys who want to use it. So it's a more sophisticated client. So on the one hand, some funders may feel like, well, this isn't great because before I could cut different deals and whoever I got, I could cut a better deal. And now everyone's pooling their information. But in fact, it helps the overall industry because as more firms become accustomed to litigation finance and understand its many benefits, the more they're going to use it. As Dave pointed out, COVID, I think, has been a catalyst to cause some firms that otherwise wouldn't return our calls. And you guys know, I mean, when you start trying to get some of the big law firms, why do they need us? They have lines of credit with lower cost of capital, or this isn't the type of firm that needs funding. Now, almost without exception, you hear of the very large firms saying, I need a financial partner in order to take my firm to the next level or continue to grow our business without necessarily incurring debt, because law firms are loath to incur debt. So this process, I think this year has accelerated things significantly, which has been a great trend, I think, overall.
Tell us about your experience of direct solicitation by corporates and businesses, Chris.
So I think historically, businesses and corporations have not come direct. They almost all have come through their lawyers, either because they're more comfortable with working with their lawyers as an interface, or they think their lawyers are more familiar with it. Whatever the reason had been historically, you would rarely have, I mean, in a given year, you may have 10 or 12 direct solicitations, and those were typically from smaller businesses. Now, fast forward to this year, Fortune 500 companies have directly contacted us seeking funding. Now, to be clear, many of them want to just understand it because they have no familiarity other than what they've read. And so a lot of it is, could you tell me about litigation finance? We have put together a group to study this and determine whether it's helpful. And it's not always just the lawyers or the general counsel's office. It oftentimes tends to be someone from finance, because they understand, gee, if I can work with this funder, I can start to change the internal perception of my group from a cost or an expense center to a revenue center. Why? Because now, instead of the general counsel needing a budget of X, they could do less than X, and that money could be repurposed or retasked for the core purpose of the business. That makes the general counsel more popular. It makes the general counsel more efficient. And it certainly pleases the accounting department and the finance department, because now they're freeing up cash flow to use for a variety of other purposes. So what we've seen is corporations directly contacting us and saying, help us understand. Certainly some of those have now led to ultimately putting finance arrangements in place. It was surprising to us, I think, at the beginning. But once we started to understand the impact of COVID and what that was going to potentially have on the economy going forward, we started to realize that direct solicitation, although oftentimes inefficient because they aren't as familiar with litigation finance, if you're willing to spend the time and have patience, like we are, and I'm sure you guys are, there is business there. It's a longer lead time, but the numbers are typically larger.
Dave, any thoughts, or want to move to bespoke programs? I think you're muted, Dave.
Oh, sorry, the dreaded mute button. The only last thought is perhaps the last bullet that we had on the screen that Chris may be able to speak to even better than us, but there does seem to be an increased uptick in interest and use of litigation finance around the world. As many people know, it sort of started in Australia and moved to the UK and international arbitration space, and then over to this country, probably like 7 years ago or so now. But recently there has been increased interest and use all over the globe, offshore, which is obviously of particular interest to this audience. There have been some good decisions in Cayman and BVI that make funding more practical there, and in Asia as well. And I think Chris can also speak to some other geographical locations such as the Middle East. But Chris, what are your thoughts on that?
Certainly, I echo what you both have said. When we started almost 10 years ago, we first did cases that were international because my practice was more geared towards international litigation and enforcement. When I started, it was primarily focused in Australia, as you said, and in London. And you'd get a smattering of it in Paris because of international arbitration. You wouldn't see much in the Middle East, Africa, other than big international arbitration cases that certain firms are known to have done for many years. What we've seen now is every year a gradual uptick in demand from places that would surprise, I think, many of the people in the audience. So both of you came from the grandfather of our firm, IMF, of which we have the highest respect for. And part of what we respect about that firm is it identified a market, obviously because of certain favorable laws in Australia, and then took that model and migrated it westward towards London and then the United States. So this concept of developing something that works in one country and then taking it on the road, if you will, and adapting it for the local market is something that they pioneered in the industry, and something that when I founded Delta, I said that's something we should be doing because everyone seemed to be focused on New York, Chicago, and London. And as you guys know, that's where most of the funders are based. And there's reasons for that. And those are important markets. But what interests me the most personally is these other geographic markets, because they have cases that tend to be large, complicated, multi-jurisdictional, and just fascinating. And it expands your knowledge and awareness of things. So we have done things in the PRC. And I think when we did it 7 years ago initially, the other funders thought we were crazy because I went to most of them and asked them if they wanted to participate. And they thought, you're nuts doing things there. Now, in other parts of Asia, including Singapore and Malaysia, those are important markets. So much so that we established an office about 18 months ago in Hong Kong to kind of serve as the base. So what we see in Asia is a growing trend. It is slower to adopt because it's just not as familiar. But if you know which firms to tap in that particular marketplace, you're going to get tremendous deal flow. And just to be clear, yeah. Sorry, Ralph. Go ahead.
I was just going to ask a question. Chris,
sure, of course.
Can you tell us, you have a Hong Kong office. Was that your first overseas office? And do you have any others at the moment?
No, actually, the first office that we opened was in Warsaw. And that's because we saw a significant number of cases from Eastern and Central Europe and the CIS region, including Ukraine. And we're figuring out, well, where do we want to have an office that calls upon it? And Poland is a very simple system from the sense of the law is relatively straightforward. Yes, it's not common law, but if you look at their courts and the transparency of the courts, if you look at the sophistication of law firms, you'll see many large firms have offices there. It's a lower cost center, so you can get the same talent at about 1/3 the cost that you could in London. And
Wow.
So I know for a number of firms have moved kind of back office operations for Europe to Poland. Also, the quality of the attorney is very strong. Typically, they will have been educated in the West or in the best schools in Warsaw, which are comparable to schools all over the world. And we happened to find someone that I thought was exceptional, who had a private equity and litigation background. And so we jumped on that. And then from there, we had a satellite office in Prague. We realized Warsaw could call upon Prague and didn't really need to have a dedicated person in Prague. And then Hong Kong. And then now, given the demand in the Middle East, our next office will be in Dubai in Q1 of next year. And then we've always had people in London. We haven't had a physical office in London. That's going to change in January when we announce a new president that will be joining us in January and who will be leading our international effort and based in London. So I think to wrap this up, tremendous opportunities are available for all the funders. If we still believe we're in the very early growth stages in the United States and London, we are in the nascent stages across the world. When we look at global demand for litigation finance, everyone assigns some huge number. I think the important thing to know, because it's hard to actually quantify that number, is there is huge disparity between supply and demand in every single market in which we operate. And it means we're in an enviable position because we can cherry pick cases and we can have a lot of investment discipline. We should continue that trend, but explore other markets, because in the last couple of months, I've seen cases from areas that we were unfamiliar with. And my last point is, just because we are talking about these somewhat exotic markets, it doesn't necessarily mean that we're litigating in that market. Oftentimes, the litigation is international arbitration, or it is in a neutral jurisdiction. So if I source a case in Saudi Arabia, it could be adjudicated in Saudi Arabia. If it was, we'd want to make sure it was pursuant to some kind of international body of arbitration laws as opposed to local law, just to make sure we got a fair hearing. But oftentimes that would be an international arbitration dispute that's heard under ICSID or a bilateral investment treaty. So you could have great exposure to more opportunities, but not necessarily more risk, which is important from a funding standpoint.
And for validity, we also identified international arbitrations as an important market to tap into. And we're lucky enough, it's often the case, as you say, Chris, that it depends on who you find. And an exceptional person in the right place, or even in a potentially right place, is far better than the wrong person in a big market. So in our case at Validity, we identified a real superstar based in Israel, and so we have a Tel Aviv office that services the Mideast to the extent that there is such opportunities from Israel, which is somewhat limited, but also handles U.S. litigation from Israeli tech companies, which was the market that Eli Schulman, our man there, had serviced as a lawyer. He's an American lawyer. Any last words on this slide, Dave, or should we go on to our hypothetical and anatomy of a term sheet?
Yeah, the only thing I would add is it actually really dovetails with this slide and the last slide, which we went over quick, which was just, you know, there are many different funders now in the market, and it's important for potential users of finance to think about what funders you know, they want to speak to, and there are funders that focus on, you know, different things, as you've sort of heard here. You know, Chris focuses, and Chris can speak for himself, but focuses on all sorts of claims around the world. At Validity, we generally focus on U.S.-based litigation and international arbitration, as Ralph just mentioned. We opened about 2.5 years ago, about $400 million in capital to deploy, and we were really, Ralph and some of us who joined him really founded the company based on client trust. And so it's just important to think about which funders you're going to approach when you have a claim that you're looking to get funded.
All right. Well, we're on to our second big slide, using our time really well here. So we're going to show you a little hypothetical to illustrate the anatomy of a term sheet. And when we thought about how to construct this panel for the most interesting way of sort of X-ray vision on how does a funder think in an efficient way about a case when it first comes in. So how do we think about claims at the earliest stage, and how do we translate those inputs into term sheets? And so we've got a little hypothetical. Dave, why don't you run through this hypothetical and I'll just say that the term sheet breakdown, you'll see it in the next slide, is really very simple. It has only 4 parts. And we think if we can all understand how the inputs go into those 4 moving parts, you'll understand how the funders work and how to better speak about your claims and how to develop these claims into funded matters. So Dave, you want to start us up?
Great. Yeah, sure. And we'll come to those 4 kind of inputs, but you know, there's other kind of facts that funders will want to know to be able to fill in those inputs, and we'll talk a little bit to preview, you know, at the end about the best way to present your case to a funder and what the funder is going to do in order to diligence it. But here with our hypothetical, as you can see, we have Mr. Nice Guy, but Mr. Nice Guy's a little unhappy right now because he has a claim and he doesn't know how to get it funded, so he's frowning. He has a breach of fiduciary duty fraud claim against a Ponzi schemer, bad guy company. He's been told by his potential lawyers that the budget for the case is going to be something like $4 to $6 million in legal fees, $1 to $2 million in what we'd call out-of-pocket costs or expenses to hire experts and travel around the world to take depositions. And the damage estimate is what he's going to be asking for in the case is something along the lines of $60 to $80 million. So that's the hypothetical that we're going to be working off of. As Ralph alluded to, the term sheet really has four main moving parts that we're going to look to fill in based on the information that we're going to try to gather from the client or the lawyers who've approached us to determine if it's a matter that we can fund and that makes economic sense. What we'll normally do when we get an approach from a client or most often a lawyer is we'll put an NDA in place right away to protect our communications, and we'll do an intake, and we'll try to gather as much information as we can from the client in order to be able to tell if we can put out a term sheet. Usually that process could take as little as a day or two, or as much as maybe a week or two to gather the right information from the client in order to be able to see if we can put out a term sheet if it makes economic sense for us to put out a term sheet. And so before I come to the four inputs, I'll just ask Chris if that process is similar to what Delta has or some other process.
It is. I think we're continually evolving our process as experience grows. And so now we have a dedicated intake and triage person that systematizes the intake process and completes a fairly detailed database that then sends messages and reminders to everyone within the firm about the new opportunity, what it looks like, who has to start thinking about putting together a financial model, et cetera. So I think we've just become more efficient as case flow has increased. But in general, yeah, it's the same process.
Great. So,
Dave, let me just,
yeah, go ahead, Ralph. Go for it.
Slide. Yeah,
please.
You know, I often say to our team that if we get these inputs, we can do a term sheet in about 20 minutes. And it's not really true, because we really need to have a couple of conversations. But with these in mind, especially the top row, you really can get pretty far into it. But why don't Dave, you start to help us understand why these are so critical and how you slice and dice.
Sure. So as you can see here on the slide, the four main inputs are: what's the funding commitment going to be? And as you'll see in a moment, how is that broken down? What's going to be the sources and what's going to be the uses of the funding is important to the funder. And of course, what the return is going to be. What's the funder going to be owed back if these are all non-recourse investments, as most people know. So what is the funder going to get if the case is successful, if there's a settlement or a judgment that's collected? And of course, these are relatively risky endeavors for us, since if there's not a good outcome, we're going to lose whatever capital we've put out. And so the returns that we're seeking are relatively high. And then how do you divide up when returns come in, whether it's just the proceeds that go to the client, if the funding is direct to the client, how are you going to share those dollars that come in? Or if the funding is going to the law firm and a funder is taking a return from the lawyer's fees, again, how are you going to divide up those fees? And we call that the waterfall. And then finally, exclusivity. How long are most funders, not all, but in every case, but many funders are going to ask for a period of exclusivity once the term sheet is signed, in order to be able to conduct a robust due diligence period and really kick the tires on the matter to make sure that it's valuable and likely to succeed. And we want to make sure that the deal is going to be available to us to complete once we've done all that hard work. So those are the four main moving parts that are going to go into the term sheet. But again, we're going to be gathering a lot of information from the client, both in talking to them and in asking for certain documents to review, in order to figure out if this potential investment opportunity is economically viable for us.
Great. Chris, any other thoughts on that?
The only other factor I would mention is collection. So we're kind of obsessive with this. So these are the four main things, but I think once we know what they want, before we talk about anything else, we're going to have a very detailed discussion about collection risk. Because to us, that's the factor most lawyers don't spend enough time on. And we need to have not only a detailed case management plan, but a plan to enforce the judgment or award. That oftentimes involves our internal investigative people and analysts, but often also a third-party firm that will help us start to build the model about what is our collection risk, because that will drive return, that'll drive waterfall, and ultimately will help us determine whether we want to do the case. What's hard for some attorneys to understand when they join us is they oftentimes focus on legal merits almost exclusively, right? Especially if they were litigators. Because as a litigator, that's what you're paid to do and trained. You're not necessarily paid to collect a judgment, especially if it's in the US. Judgment enforcement is fairly straightforward. Outside the US, it's a completely different story. So we will spend as much time going over collection and the path to collection as we will legal merits. And so what I try to tell everyone is I'd rather fund a case that had 100% certainty on collection and a 60% chance of winning on the merits than a case that had only 60% chance of collection and 90% chance of on the legal merits.
Right.
That's very wise. Very wise. And we I guess we short-circuited. We assume collectability in doing a term sheet, but you're absolutely right. It's the critical question that trial lawyers are very, very prone to forget from their practice.
Yeah,
Right.
and we've moved ahead to the next slide, but that emphasizes the point that while there are those four kind of main inputs, in order to figure out how you really address those inputs, and specifically there's a threshold question of whether you can put a term sheet out in the first place, and then if you can put a term sheet out, what the return that the funder is going to need to basically account for the risk in the case, because every case has risk. There's no case that has no risk, or you wouldn't be seeking funding for it. There's a lot of kind of sub inputs that go into that, or facts that we need to figure out in order to figure out what the return structure would be. So bringing it back to a little bit to our hypothetical here we have a case, offshore v. Ponzi. The claim type and the merits of that claim, as Chris alluded to, are very important. And so what type of claim it is will have a heavy influence on what type of return structure we might seek. If it is a simple breach of contract action versus a complicated antitrust or patent action, the returns could look very differently. What kind of risk sharing or risk taking the lawyers and the clients are willing to do is really important to many funders. We sort of start off at Validity, at least, with the proposition that we'd like the lawyers to be 50-50 with us in sharing risk on the fees. And that's a critical input. Now, not every large firm especially can do that. And so it's not that all of our deals, for example, have 50-50 risk sharing, but we always want there to be some significant amount of risk sharing on the part of the lawyers. First off, it helps us align interests by having them have a significant amount of risk. Once we make the funding, we're not going to have any control over the matter. We specifically disclaim control. And so having the lawyers aligned with us in the risk sharing helps sort of fill in that hole. But it also helps, it's a proxy in a sense for how strongly the lawyer really feels about the case. So that's why here, the third little box, will the lawyer be 50-50 risk share or taking some other share of risk is an important consideration for us as we're coming up with a term sheet. And then, of course,
move faster, Dave, because we're going to run out of time. So why don't you hit highlights?
Sure. What the economics are, what the budget, what the fee budget is, what the cost budget is. And then that's the most common usage of funding, fees and costs. But then funders can also provide working capital or operating capital or kind of a early monetization event for the client. So that's the working capital box. And then time to trial, how long it's going to take to get to a resolution, or really to get to money flowing in, to get to a collection, if it's a judgment enforcement case, is a critical component of how we're going to price it. And then, of course, what the damages are. How much of an upside is there in the case? Is there enough room in there for the funder to get a return, for the lawyers to get a return if they're taking risk, and for the client to be getting a return? We're very focused on making sure that the client's going to be getting at least 50 to 60% of the proceeds. We think that's as a matter of fairness and also for alignment of interests. And then what's the client going to be contributing? What kind of skin in the game are they going to have? We're always trying to make sure that the client has some skin in the game that's meaningful to them, again, so that interests are aligned. And then the exclusivity period that we mentioned before, how long it's going to be. And sometimes you can have a case that's a little bit safer than others, especially if there's principal protection, which can lower the cost of the funding.
Great. Chris, I think just to make one word, I think you might want to comment on the client contribution, and it could be that your cases are of such a slightly different nature that it's less amenable to such things.
Sure. I think 3 quick points. One, on the client contribution. If we do a lot of stuff in the offshore world, so in insolvency estates, it's not practical to ask the estate to make a contribution. Also, you oftentimes have smaller claimants, companies that have essentially been put out of business because of malfeasance of a larger player, and they're generally not going to be able to contribute things. But I agree with your desire to align interests as much as possible. That comes through the law firm primarily, risk sharing. 50-50, I think, is ideal. We have some law firms that are willing to do all the fees on contingency and they only want us to do costs. Those are great cases because of the strong alignment of interest. Some larger firms are going to have difficulty with 50-50 and they may do something between 25 and 1/3. And that generally works for us. Client contributions is not something that works in all of our cases. As I said, we do want to see an alignment of interest, so that generally will be taken care of through structuring devices and waterfalls to ensure that they are constantly cooperating with us. We spend a lot of time up front. We meet every single client, no matter where they're located in the world. Someone will go from Delta to meet them and try to figure out if they're commercially reasonable. Are they going to stay the course? Do we view the case the same way? Do they have the same settlement expectations? So I think the important thing from what you're saying, one of the important things is aligning interest between the law firm client and the funder is critical. It needs to be done, especially as the numbers get larger. And then the one other observation I'll make is on the prior slide, but it also is implied in this slide.
Sorry, there you go.
Funders look to see that the total budget is no more than 10% of the likely outcome. So here you see that it is between, I think, 5 and 8 million if you include costs and attorney's fees. And the expected damages is 60 to 80 million. That is the ratio that funders want to see. I would just add that we don't focus on what the damage range is. We focus on what the likely outcome is going to be, because many lawyers are going to tell you this is a $500 million case, and 490 million of it is lost profits and 10 million of it is sunk costs. And we know as funders, lost profits are great to argue. You don't always get them. So we're going to run a model, a decision tree, a weighted average probability analysis. And then we're going to say, you may say it's 60 to 80. We think it's more likely between 30 and 50. And so in this example, we would say your budget's too high if it's 40 to 50. The law firm is going to either have to take on more risk, which I think is fine here, or the client's going to have to do something in order to get us within that 10% window.
So with just about 7 minutes left, I'm going to push us to try to get through all these slides. Dave, do your best here.
Yep.
And I think Chris has covered some of this as well.
Yeah, that's exactly right. We'll fill in the holes here. We take the budget. We ideally, if we're going 50-50, we're going to take half of the fee budget there and take $2.5 million. It's kind of right in the middle of the range. We're going to take part of the cost budget and try to make the client responsible for some of the cost budget there. So we fill in $1 million for that we would pick up in the commitment. The client would be responsible for the next $500,000 and anything over. And with the fee budget, ideally we have a capped fee budget with the law firm. So we're providing 50% of those capped fees. They're investing 50% of their time, plus they are responsible for anything over the fee budget. So it's going to make them more responsible in how they use their time. And then sometimes the client will need working capital, and we can provide some of that as well. But to Chris's point, when we see a damage range, mentally we're haircutting it kind of right off the bat. It depends on the type of case, but if there's a $60 to $80 million damage range, you're not going to resolve it for that amount. You're maybe going to resolve it for half of that. And so we want to make sure the 10-to-1 ratio that Chris mentioned before, makes it worthwhile. Here we're sort of just about there, but it's it's getting a little skinny, so we need to be careful about how much we're going to commit to this matter.
And how do we figure out returns, Dave? Let's do that. Let's go.
Yep.
To that.
So we're going to go right to the next page here. All funders have different models, and within each funder, there's many different structures that funders use. A very common structure that you will see here is the greater of. So we're talking about a greater of return structure that escalates over time. The escalation is in part because our money is out there at risk for a longer period of time, and many funders are very focused on their cost of capital and their IRR, and which will lower over time if the return that they're getting doesn't increase over time. And so we're matching both risk and return here. And again, back to what we said before, based on the type of claim it is, the amount of time we estimate to completion, and the various risk hurdles will affect the pricing. If it's a riskier case, those multiples and those percentages will go up. If it's a less risky cases, those percentages and multiples will go down. And then there's other structures, of course, besides the greater of. It could be just a multiple, just a percentage, or maybe a combination of a multiple and a percentage.
Do you want to talk about the priority and how in this example we divide up between the principal and the recovery, and
Yes.
how that's so important? We have about 4 minutes. I'm just
Sure. So
our guys to that.
Yep. So the most funders are very protective of their principal and will almost always take priority of the dollars coming back in to cover what they've deployed. So sort of what we'd say is 1x priority. Sometimes that increases, and funders will take a 1.5 or 2x preferred return or priority. But generally, starting from the proposition, they're going to take at least 1x, getting back what they deployed first from any dollars that come in, and then sharing pro rata or pari passu with the lawyers usually next, and then with the client after that.
Terrific. Chris, any quick comments on this section?
No, I think everything that Dave has said is consistent with us. We want to ensure that collectively the claimant's getting at least 50 to 60%, that the lawyers are getting some upside to aligned interest, and the waterfalls are consistent with what you're suggesting here.
Right.
Great. We touched on exclusivity. There's not much more to say except the rationale for exclusivity, again, is so that the deal is available to the funder after they've gone through a lot of work, time, and often out-of-pocket money. As Chris said, often hiring outside third parties to validate the collection model or the damages or the merits of the case.
Terrific.
Finally,
Right,
oops,
so
there we go.
Yeah, go ahead. Yeah, well, how do we get from that term sheet to the closing, guys? We know there's a period of exclusivity for the underwriting. Talk about the sequence of the merits due diligence, the contractual negotiation, and how claimants can make that 30 days work.
Yeah, so I'll go first and then turn it over to Chris. I think ideally, the more information we can get up front from the lawyers and the clients, the easier it is for us to diligence the case. The easier it is to figure out if we could put out a term sheet to begin with, and then the easier it is for us to diligence the case. The gold standard is getting a nice memo that sets out both the strengths and the weaknesses, what the warts are, what the risk hurdles are. We're going to find them anyway, so putting that out up front both helps us move quicker and also gains credibility for the lawyer and the potential funded party. When we discover big potholes in the matter late, it hurts the credibility of the client, and it makes it harder for us to get to yes. So we're trying to figure out the merits, the collection. We're looking at things such as the venue and who the trier of fact might be, and also who our counterparty is. We're doing diligence on that, as well as on the defendant and their ability to pay. Ideally, we're going to try to complete the transaction both by completing our diligence and completing a negotiation of a final funding agreement with the client in parallel during that diligence period, so that we can close and fund at the end of the due diligence period and exclusivity period. I'll just pause there and just ask Chris quick if he has anything to add on that.
We have 1 minute left, Chris. Why don't you take, we have a question I want you guys to try to answer too. So if you
Sure. So what I'd say quickly is it's all about creating a partnership of equals. So I liken it to when you want to buy a house, you need a mortgage, you look at your lender and you've got to provide all of this information, which oftentimes is burdensome, but you accept that this is part of the process in order for you to realize your dream of owning a home. It's the same thing with us, as Dave said. We're going to find out everything about the background of your clients, the lawyers, the track record, everything you can think of, because we have a lot of money. We always use a third-party law firm to validate what we've done. We almost always have a background check, an investigative firm. So being upfront and forthright and creating this partnership of trust really is what it's all about. And I think sometimes that's lost on some of the lawyers that come to us, and they act as an advocate and only tell us the good.
Well, thank you, Chris. It's great comments. Sure. We're down to the wire. Thanks, Chris. Thanks, Dave. It's been a lot of fun to try to present it in a nutshell. Thank you.
Thanks very much, everyone. Enjoy your day.
Thank you, everybody.
Thanks for watching. Consider subscribing to our investigative news and documents service and attending our events. For more information, visit offshorealert.com.